Best to kick off so as to hopefully give you an opportunity to ask some questions at the end. I'd like to start by welcoming you all on behalf of the American Society, also on behalf of Columbia Law School's Human Rights Institute, to this wonderful fireside conversation, although we appear to be seated on a panel table. But I do have the great honor to be joined by two very special guests. To my right, Tim Eicke, Judge of the European Court of Human Rights, and to my left, Meg Satterthwaite, UN Special Rapporteur on the independence of judges and lawyers. I would also like to start by thanking CBC Law for their support for this session. It's very good to see members of CBC Law here in the audience today. Now, the subject and focus of our conversation, upholding the rule of law in a time of crisis, could not be more timely. But sitting here, I'm reminded of the unforgettable address given to the American Society 3 years ago in this very room. It was an address given by the Nobel Peace Laureate, Maria Ressa, who also happens, unfortunately, to be my client, subject to 5 actions, criminal and civil, in the Philippines. Maria 3 years ago spoke of the rise of disinformation and the onset of truth decay. She pointed to the concerted attacks on 2 critical democratic pillars: attacks on media freedom and attacks on the rule of law, attacks on journalists, attacks on lawyers, attacks on judges. Ladies and gentlemen, 3 years on, we meet amidst gathering clouds and raging storms. Democracy and the international rules-based order are under very real strain. Some say they're close to breaking point, others say already broken. War rages on in Ukraine, war rages on in Gaza, and there is the threat of new or renewed conflict in almost every corner of our world. Now, last week I had the privilege of addressing the International Journalism Festival in Perugia, Italy. And it struck me last week that the great majority of the panel discussions at the festival were focused not on journalism and its bright future, but rather on the dire conditions under which journalists are operating today. The discussions centered on the continued rise of mis- and disinformation, journalism in exile, journalists' safety, or I should say lack of safety, arbitrary detention of journalists, targeted killings of journalists, widespread impunity, and of course, lawfare. Lawfare, I think it's fair to say, was the leitmotif of last week's festival: the weaponization of the law to target human rights defenders, to target journalists, and to target the lawyers who seek to defend them. And in the 3 years since Maria gave that address in this very room, I could not have anticipated that our successful challenge to the Russian Federation's foreign agents laws for Radio Free Europe, Radio Liberty in the European Court of Human Rights would be followed by attempts in this country to shut the broadcaster down. Nor could I have anticipated that the emergency visa for journalists at risk, established by numerous states on the advice and recommendation of our high-level panel of legal experts on media freedom, would be in such dire demand. And of course, all the while, the targeting of human rights defenders, the targeting of journalists, lawyers, and judges continues unabated. So today, the question of upholding the rule of law, whether at home or abroad, whether domestically or internationally, this is a topic that can no longer be debated solely by reference to abstract concept. It's become a core question for us all, and it's become all too real and all too pressing. This is what we're going to discuss today, and I can't think of 2 better fireside companions. To my right, Judge Tim Eicke is the United Kingdom's judge at the European Court of Human Rights. Tim is a dual British-German national. He studied law in both countries first at the University of Passau in Germany, and then at the University of Dundee in Scotland. Called to the bar, Middle Temple, 1993, appointed Queen's Counsel in 2011, made a bencher of Lincoln's Inn in 2014. Tim has been serving at the European Court of Human Rights since September 2016. To my left, Meg Satterthwaite, Professor of Clinical Law at NYU School of Law. There she runs the Global Justice Clinic. She also helps lead the Bernstein Institute for Human Rights and the Center for Human Rights Global Justice. And I think it's fair to say, Meg, that you've been involved in international human rights work for decades, both as a scholar but also as a practitioner. And of course, from October 2022, you were appointed the UN Special Rapporteur on the independence of judges and lawyers. A very warm welcome to my two discussants. We'll start the conversation now, and as I said at the outset, hope to find some time at the end for some questions from the audience too. So please do start thinking about some questions for our guests. I want to start with a question to you both, and perhaps, Tim, I could start with you. I don't think there's very much debate that we're witnessing a global blacksiding in democratic norms, including respect for judicial independence. In your view, what are the most urgent threats to the rule of law today?
Thank you very much, Jan, for that introduction and that question, and thank you very much all for coming. It's a great privilege to be here and to share a panel again, or a fireside chat with Meg. Now that's a huge question, which I'm not quite sure how to unpack. I think the challenges to the independence of judges is the independence of judges is crucial to the rule of law and to maintaining the independent dispute settlement that is required for a civilized society and modern democracy to exist, and therefore is at the heart of the concept of democracy as we understand it. Now, the biggest challenge we see, I think, from the European Court of Human Rights is one, the interference with the independence of the judiciary. But ultimately, it's in fact, even though that's not reflected in our case law as much, it's the interference with all those institutions which are perceived to be, or which are meant to be independent. That is the judiciary and the lawyers who serve the legal system, that is universities, that is the press. So that's the biggest threat. We, of course, have also been, and during my time on the court, have had, in a sense, probably the ultimate threat, which is the invasion by one member state of the sovereign territory of another, which is a case that's currently still pending before our court. But that, of course, is something I think certainly in Europe nobody anticipated would happen again, perhaps foolishly, but anticipated would happen again, and led to some very serious questions to be asked also about the rule of law at the international level and how do we respond to those kind of transgressions. I don't want to minimize it, but that's in a sense what it was of our basic rules. So there's a that's a whole range, but there's, you mentioned disinformation, there's various other factors which I think ultimately all play into the threat to those independent institutions, because they're designed to undermine or weaken those independent institutions on which we all depend so heavily for, as I said, the maintenance of our democracies.
Thank you, Tim. Meg, what about from your perspective? What are the most urgent threats to the rule of law today?
So thank you so much, John. And I want to, again, just echo my also thanks to you, Tim, for being here today, and for all of you for this conversation. I do look forward to it as a conversation. So I think what I'll do is adopt a lot of what was already said, and then maybe drill down on the piece that's about targeting and trying to interfere with judges and lawyers. So one of the main things I do in my role is to get communications, to get letters and complaints from judges and lawyers all over the world who are saying, I'm being attacked, my independence is being interfered with, please help me out. So on the basis of those letters over the past several years, I've created a taxonomy of attacks. And so I'm just going to very briefly set it out. So these are the kinds of attacks on both judges and lawyers that we're seeing in this kind of larger process of autocratization. And I'm going to use that term because it underscores that any country can become more autocratic. So it doesn't matter if you already started out in autocracy, if you're starting as really a liberal democracy, there's always the ability to go further in that spectrum. So 4 main ways this is happening. The first is, of course, one we talk about all the time, capturing. So attempts by political powers, especially the executive and the legislature, to capture judges and lawyers. So both to try to pack courts, to try to put certain kinds of leadership into bar associations, to really reshape those institutions in the face. In the desired realm, in the desired ideology, I think would be the best way to say it, of those powerful actors. The second is curbing. So if you can't completely capture the institutions, then what you can do as a powerful actor is to start to shrink their power. And there are lots of ways this has been done. With the courts, it's often jurisdiction stripping or jurisdiction limiting. It's also just very straightforwardly reducing resources. So we've seen things like taking away the ability of judges to hire a full staff, as an example, or to simply have money to run their systems as they should. That's curbing. And then the other 2 kind of pieces of the taxonomy are attacks on the individual people who take up the system. The first is instrumentalization. So instrumentalization is a way of using the law itself, so using criminal law, using administrative law, using procedural pieces of the system to go after independent judges and lawyers. And so this looks like things like criminalizing and prosecuting judges, for example, for simply carrying out their duties, or prosecuting prosecutors who've been going after corruption, et cetera. So that's instrumentalizing. The final is, unfortunately, simply going after them, attacking. And there you see everything from kind of ad hominem attacks from officials all the way over to supposedly private actors taking very vicious attacks, including, unfortunately, in some places, assassination, with either the acquiescence or direct links to those in power. So that's kind of a taxonomy, and I'll stop talking here, but maybe I could go into any levels of those.
In that taxonomy, I just by way of follow-up, in that taxonomy, what about litigants writing to you and saying that there are no independent judges or lawyers willing to take my case? Do you deal with those sorts of cases?
Absolutely. And this, I think, happens a lot when there has been instrumentalization of disciplinary systems, or the public shaming and naming and denigrating of litigators themselves. So people who will face direct consequences if they take on certain cases. And that's a very enormous problem that then has these systematic impacts on who can get a right to defense.
So what is your advice in that situation? As a lawyer who has been told that if he takes a certain case, he will get in trouble, I would ask for your advice. What is your advice?
So my advice is this is a collective action problem. And that's where strong bar associations and strong solidarity across the bar is really important. You see, I was just actually in Eswatini in Swaziland, and I'll just give an example there. Independent lawyers who have taken up the cases of those who are charged with terrorism, for example, or even who have just been charged for protecting and standing up for democracy, have been losing their private clients. And I think that's an example of where if all the lawyers can act together and show that they support the rule of law, that's going to take away that kind of way of weaponizing things by shifting things and showing that the whole bar is going to stand up.
Thank you, Meg.
Can I perhaps there's an interesting example of that, I think, at work. How it will work and how effective it will be interesting. But of course, in the European context, we see that how the bars and the European Council of Bars, in a sense, lobbied together, the Council of Europe, for a convention for the protection of the status of lawyer. A first in the world, I think, but it is exactly an example of the bars clubbing together and kind of lobbying the states for adopting, and the international organization, a protective mechanism. which, if nothing else, lays down certain standards which become hard law once adopted, and then give courts tools to play with. So I think it's exactly it's an example in Europe where that has borne some fruit.
Could I just develop on this theme, and I want to come back to you, Tim. I mean, you sit as a judge on an international court that applies international law. But of course, the ECHR, the European Court, is not an appeal court. And there's always been a tension in the jurisprudence of the European Court of Human Rights between striking a fair balance between national sovereignty on the one hand and international legal oversight on the other. One of the reasons that you have to exhaust domestic remedies before you go to Strasbourg, one of the reasons that the court sometimes applies a margin of appreciation in individual cases. But how do these doctrines, how are they supposed to work? How's the European Court of Human Rights supposed to work if there are very fundamental or systemic issues at the national level on rule of law and on independence of the judiciary? Because you obviously weren't set up as a first instance court.
Well, I think, the question you pose raises two issues, I think, from both sides. So if there is a fundamental issue, of course, you only have to exhaust remedies which are available and effective. And if they're not, then we will have to act as a first instance court, which we're not set up to do, and poses its very own challenges in terms of procedure, assessment of the evidence, and also embedding the case and the solution of the case in the society in which it has to work. So that's a real problem, which is why, in a sense, those rules are there, and I think they are important. But there's another way around which I think is important to highlight too. I think they are hugely important mechanisms in strengthening the back of, or having the back of, the domestic judiciary. Because it's been clear from our jurisprudence, and we've been clear throughout, that the first instance courts are the domestic courts, and they are human rights courts in that context. And we try and make sure that we engage through our judgments and otherwise in dialogue with the judges. And when you have cases, for example, where a violation is found because an appellate court messed up in a neutral, putting it neutrally, or was captured, but the first instance courts, in fact, did get it right, we, I think, frequently see it as our role also to say, well, actually, the first instance court got it right. It was the appellate court where the problem was. In a sense, trying to have, as far as we can through our judgments, also, as I said, to kind of support the first instance judges who are trying to do the right thing in very hard circumstances with an appellate court or other structure which has then failed, rather than lay the blame on the state, where in the state then the blame gets passed down, no doubt. We kind of reach through, because we have that dialogue with the courts at every instance, in a sense, we can reach through and say, well, actually, the first instance courts have gotten this completely right. Where it went wrong was X. And therefore, hopefully, helping domestic judges resist some of the pressures that will be brought to bear either by appellate courts, captured or otherwise, or by the executive, because they actually feel seen and heard by us. And those who might exert pressure will know that they are seen and heard by us.
But one of the trends, just thinking about this procedurally, one of the trends I've noticed in Strasbourg is actually some of the domestic courts, especially the apex court, sitting on a case for a very long time. And knowing that for the applicant, that leaves them with a dilemma. Either they petition the European Court of Human Rights and risk a single judge saying it's inadmissible, or they have to wait for an indeterminate period of time. How's the court dealing with that issue, in your view?
Well, I think that's, in a sense, quite fact-specific. In a system where there is an inherent systemic problem with delay, that will feed into whether it's an effective remedy. And if it's not, we will step in. If, however, it isn't, then it becomes difficult for the court, because the court, as a court, can only deal with cases that are brought before it subject to the admissibility requirements. And if we don't have the evidence to show that there is a systemic inefficiency, then it becomes quite difficult. That said, of course, if a single judge were to reject a case on on that basis of non-exhaustion. That, of course, and I appreciate for the client that isn't the most attractive solution, but that's not the door shut completely.
No, of course.
That's the door shut for the moment. Yeah. And depending on where it goes, and that's the kind of intermediate cases where you think there is the start of a systemic problem, it might not go to the single judge. The single judge might refer it to a committee of three who will then perhaps declare it inadmissible, but say something about the delay, which starts building the case to it either becoming systemic or in those systems which are responsive where it is the delay is caused by some of the other pressures like funding and backlog. It just puts it on their radar that, in fact, Strasbourg is watching. So it's more subtle than the binary between single judge inadmissible and otherwise.
Meg, just a question, obviously hearing from a sitting judge. How do you deal with a case or a complaint or a party raising awareness with you about a situation in circumstances where there are also ongoing proceedings? Might be at the European Court of Human Rights, maybe at the Inter-American Court. What's your approach to that as a special rapporteur?
Right. It's a great question, and I get this question a lot, in particular from states. So we're a non-judicial and also not even a quasi-judicial mechanism. We really exist to bring allegations to the attention of a government. So we don't have any exhaustion requirements. And if there is a case that presents, for example, due process issues at the initial trial level, we do have the right, and I would say the obligation, depending on the facts, to bring those issues to the attention of the government. It is delicate in my mandate, of course, because part of what we're saying to governments, and we address the government through the permanent mission in Geneva, which means the executive, I need to be careful not to be telling them something that they need to be telling judges, right? So there is some wordsmithing and some care taken to make sure that my concerns are brought forward in a way that is appropriate and does respect and underscore that respect. But it is very different than a mechanism where one has to wait for the exhaustion of the entire domestic proceedings.
Can I perhaps just add to that? And this is, of course, from the perspective of a regional court, and before we came up we talked about that though we have independence of judiciary problems in Europe, they pale into significance to some of the problems elsewhere in the world. But I just wanted to add to that, in the cases that come before us for consideration, of course, special rapporteurs like Meg can make and do make submissions, and we look at them very carefully. And they, of course, have access to evidence, which is sometimes really helpful to a court like ours. But then I appreciate, as a special rapporteur, one has to spread one's resources carefully. Yes. And as I said, I think on independence of the judiciary, problems elsewhere are probably more pressing than in Europe. But just to make the point that actually there are mechanisms engaging with the courts, the international courts and the regional courts, by which special rapporteurs have had influence on an evidential basis and on a legal, on the law, in the way we've dealt with cases.
Tim, just back to the European Court of Human Rights. I mean, you're talking about, decisions, finely balanced decisions that need to be taken on admissibility or anticipating, systemic problems. But the other side of this is that the court itself has faced increasing criticism and even open hostility from some of the member states, the Council of Europe. How can the court maintain sort of its authority, its legitimacy in this climate that we're in at the moment of rising nationalism and populism?
That's a fascinating question, one I think we've been grappling with for the 9 years I've been on the court and will continue to grapple with. I think there are multiple aspects to that. The first is, I think, to continue to act as a court of law and not to succumb to some of that pressure. I mean, that may sound like a simple point, but it isn't, because especially for a regional human rights court, there is a perception in some quarters, both supportive and hostile, that a court like ours is in fact an intergovernmental NGO rather than a court of law. And I think it's important that we continue to act as a court of law. And that puts certain constraints on the way we act. And you see that with the approach we take to the living instrument doctrine and various other aspects. But that, I think, is important. The other is communication, is dialogue, is explanation, it's transparency. The first is, I said, we are engaged in dialogue with the domestic courts, and that's a hugely important, I find through my 9 years, it's been a hugely important aspect of our work, is to engage in a dialogue with the domestic courts, that we all feel we're in this together. So rather than allowing a wedge to be driven through the national judges and us, which leads the judges domestically to, because they're frustrated with some of our judgments, and I get that, to have unnecessary swipes at that. We're part of the same kind of part of the same system. The other is to communicate what we do to the outside world, and to that extent, we do a lot of, we make our case law available. There's lots of press work being done, quite careful to try and explain what we do and myths and kind of counter certain misrepresentations which may appear. That, of course, is very difficult for a court of law because ultimately we speak through our judgments rather than otherwise. And the third part is education. I think one of the things that's become clear to me, at least as an observer, not necessarily because I'm a judge, but as an observer looking at the whole of developments in Europe and beyond from the vantage point of sitting in Strasbourg, is how much, certainly in Europe, particularly Western Europe, we've just taken so much of this, far too much for granted. And actually they're kind of restoring some base understanding of the separation of powers, the importance of the rule of law, the importance of the independence of judiciary. Now that's coming from a court, again, has to be quite carefully done, because those who criticize us will say, yeah, well, you would say so. But it is part of that, dialogue which I think needs to be had. We've, for too long, I think, taken all of that, especially those in the more established democracies and jurisdictions have kind of taken that for granted. That's what that's what the Magna Carta says, or that's what the Constitution says. But in our educational system and in our universities, I think we've neglected far too long actually teaching some of those basics, that they become, as they are for us who work this every day, a kind of just an inherent certainty rather than a contestable issue.
What about dialogue with the international judiciary? Does Strasbourg undertake that? Other regional human rights courts?
Yes, so we do have a regular dialogue with both of the with the two other regional courts, the African Court for Human and People's Rights and the Inter-American Court. And in fact, we just had a delegation from the Inter-American Court visit us about 6 weeks ago. So we have an ongoing dialogue with them. We do have an occasional dialogue with some of the UN committees. That is more, that is not quite as structured, but yes, we do. And we have a regular dialogue with in the European context, of course, the European Court of Justice, which is an important interlocutor because 27 of our 46 member states are subject to that court's jurisdiction too.
Meg, I just want to ask a different version of the same question. I've represented David Kaye when he was UN Special Rapporteur and Irene Khan afterwards, and seen the open hostility that they have received from states. So how do you deal with that in your capacity as a UN Special Rapporteur?
That's not a question I expected you to ask me. I would like to dodge that question. I don't think, I mean, I think that we expect critique, obviously.
Yes.
We expect even vociferous disagreement and objection often by states. But what I think we don't expect is personal attack, threats, and things like that. And unfortunately, those things really do happen. Other colleagues, and here I'll mention, because it has been so clear, attacks on my colleague Francesca Albanese, the Special Rapporteur on the occupied Palestinian territory, who's really come under serious attack. Those things are really unacceptable. And I'm very happy to say that I think the UN human rights system has made that very clear. And that's very important. But let me use your question to turn it a bit and say why it's important for us to think about attacks on judges as also unacceptable. So I've been really struck lately by, here in the US, the White House spokesperson, every time she talks about judges, starting out by saying, this unelected federal judge. And it really underscores for me the kind of discourse that's not only prevalent here, but also has been prevalent in many other countries, and I'll just mention Mexico here, about judges being not legitimate because they're not elected. And this is part of a big populist push to denigrate and to delegitimize judges and to say that they're not democratically representative and therefore they're not legitimate. And I think it behooves all of us, I think, who really care about the rule of law to articulate in a way that people can really relate to why judges are not elected, why judges are beholden to the Constitution, to the law, to international human rights, and that's where they get their legitimacy, that it's a different direction of legitimacy, but it's absolutely as legitimate as a democratic election. And so I think we have to be very alive for that kind of attack and start to intervene.
No, and sorry, please.
No, because that raises a number of interesting points, because we hear that debate too. I mean, one of the criticisms we hear frequently about courts judges at my court, of course, is these unelected foreign judges. And just to show that actually this emphasis on elected is just a label. It actually bears no resemblance to the reality. It's the fact that certainly in the jurisdictions I come from and I'm familiar with, I'm the only judge who is in fact elected. Because at the European Court of Human Rights, 3 candidates are put forward by a member state, who are then elected by the elected representatives from all the 46 member states, who elect the judge for a single non-renewable term of 9 years. So, in fact, I am an elected judge. But it also shows, and I think that's the other problem, which is why I made the point about teaching the basics again, is it misunderstands what democracy is about. It starts from a premise that democracy is a purely majoritarian system, which, of course, your constitution, insofar as the UK doesn't have a written constitution, but our constitutions in Europe make quite clear that that's not the case. Actually, democracy is not a purely majoritarian system. In fact, it is designed to anticipate that the current minority may be the majority of tomorrow, and therefore these safeguards are important to enable that balance to continue to operate for our democracies to stay healthy. So it belies a complete fundamental misunderstanding, deliberate or not, of democracy too.
In many cases, deliberate, because we have seen this story play out. So take Poland, take Turkey. The conversation at the start, 10 years ago, whenever it was, unelected judges, got to get rid of them, court packing, and then lawfare through prosecutors and judges who are very, very close to the government. And then all of a sudden, the conversation becomes, well, if you arrest a mayor, it's all the rule of law because it's all done through prosecutors and judges. So it is, this is not the beginning of the story. We've seen the end of this story in many, many countries around the world. But I do just want to shift emphasis for a moment and discuss with you both the challenge of impunity. Impunity, unfortunately, is on the rise. Impunity for war crimes, impunity for corruption, impunity for abuses of power. And I want to ask, and none of these questions have been easy to my discussants, but I do want to ask, and I'll start with you, Meg, if I may, why is accountability so elusive in the current system?
This is an impossible question to answer. But one thing I will say is that even though that is true, that accountability is elusive, what you do see right now is a really popular kind of groundswell of desire for it and demanding of it. And so I think the fact that there has been an effort to, for example, go to the International Court of Justice in times of strife and really to try to put into play that principle of law, not war, which of course came out of Nuremberg, that's something to hold on to and a piece of hope. And then similarly, you have the International Criminal Court taking lots of important actions. And I would like to say here, one of the reasons impunity continues is because you then have things like US sanctions being imposed onto the chief prosecutor of the ICC, which is really a direct attack on the rule of law. But at the broader level, I do think these efforts, or this desire from people to have accountability means that we can start to see kind of networked abilities and network capacities and opportunities for accountability within domestic systems, and then also a really important focus on the regional systems and the way that there can be accountability closer to home if the international institutions are unable to get, for example, jurisdiction over individuals because, for example, members of the ICC are not carrying out their obligations to arrest and transfer individuals under arrest warrant.
Tim?
Well, I would kind of want to echo that, in a sense, slightly optimistic take on this, because it seems to me there's a real value in the kind of multi-layered level of protection that international law now offers. And of course, it's a relatively young system by our standards anyway. And you mentioned the increase of the cases at the ICJ. You see the efforts in Europe being made, the negotiations about a special tribunal on the crime of aggression in Ukraine. You see the Court of Human Rights having taken a deliberate decision to continue to hold Russia responsible at the call of the Committee of Ministers too. So it isn't just the court to hold Russia responsible for any violations that have or may have occurred within its jurisdiction. Until 6 months after it was excluded from the Council of Europe. You see, the exclusion from the Council of Europe, rapid by an international organization. So I think there are multiple layers of legal attempts and people turning to the law, individuals and states turning to the law to see accountability be achieved. I mean, in the case between Ukraine and the Netherlands against Russia, which is currently still pending before our court, 26 of the member states intervened in order to in effect, encourage the court to hold Russia responsible. Now, we all know once it gets into the nitty-gritty of the legal argument, yes, that becomes a bit more complicated. So that's one side. So I think the multi-layered level of international of protection is really helpful. And in Europe, we see it at the moment because it's quite dense. Of course, we have the Court of Justice, we have the Court of Human Rights, we have the ICJ. In other areas of the world, of course, that density is much reduced. But the other thing that strikes me, and again, I think it's a point Meg just made, is also in the popular discourse. Yeah. All of this is measured by reference to legal standards, which international law, including courts like mine, have spent the last 75 years to establish. And even the popular discourse measures conduct by reference to law and calls for accountability by reference to standards of law, which pre the Second World War you wouldn't have had a standard to measure it by, and you wouldn't have been able to have this dialogue by reference to standards, legal standards, which are contested by those who don't like it, but in a sense are there as lodestars.
Meg, did you want to come in?
Nope.
No. Something I noticed in this year's annual meeting, and I'd welcome, is that there are many participants on panels who are not lawyers. And the situation is such that we can no longer afford for journalists only to be talking to journalists, for lawyers to be able to talk only to lawyers about the situation that we're facing. And it behoves me, as someone working in media freedom now, to ask you some questions about the fourth estate. I mean, some in the room will know that the United Kingdom and Canada came together in 2019 to establish a media freedom coalition of states. And this media freedom coalition was built on 3 pillars: the states themselves, then an independent panel of legal experts on media freedom, one that I have the privilege of co-chairing, and then, of course, the media freedom NGOs in the third pillar. And the idea behind this media freedom coalition was to energize efforts at the United Nations and at the regional level. But as Tim said, when it comes to the detail, the nitty-gritty, it can become complicated. And I'll start with you, Tim, where do you see, where we are in terms of international cooperation, where we are in terms of tackling some of these issues in silos rather than holistically? Are you optimistic? What should we be doing as an international law community? I ask you this not with your judge's hat on, but as your member of the American Society of International Law hat on, if I may.
Well, I mean, as I started, I think I've never been one for silos. And as my first answer built on the fact that these attacks are to all the kind of institutions which are meant to be independent by design in our societies. And journalism, of course, and journalists are an important part of that. There is a big issue about disinformation, which you mentioned from your festival, which it poses a huge problem for a court like mine in order to find a way of addressing that, because you have to balance it with freedom of speech, which we protect too, and therefore it becomes quite difficult. The third thing that I notice in lots of the criticism of our court is that, in fact, it is driven by parts of the press. Yes. And therefore, there seems to be, and I don't want to overstate this, but there seems to be an element of and this isn't state capture, but capture of the press, yes, which pursue a political angle, which is part of which is to undermine the court and the rule of law. And just coming back to your example of and your question to Meg, which she, I think, rightly dodged, but just to give an example of judges, I mean, we had, when some of you in the room may recall, there was the United Kingdom government had adopted a policy to take those who've come to the United Kingdom by small boats, as they called it, to the UK. The plan was to take them to Rwanda for their asylum claims to be assessed there. And one of our duty judges at the court issued a Rule 39, which required one of the people on the plane to be taken off the plane, and the state complied. And domestic courts then issued further injunctions, and therefore the plane was ultimately cancelled by the Home Secretary. But what the reason I bring this up is because at that time we didn't name the duty judge. And by elimination, the press had identified that it could only be 2 of the 3 sitting duty judges. And one of my colleagues, who was one of the 2, was doorstepped twice by a journalist at his residence in Strasbourg. And a journalist camped outside the court and I don't think it can be put any other way, harassed some of my colleagues to find out who the deciding judge was. Now, one can have an argument about whether it was right that we had a policy of not identifying duty judges. But that was one of the problems. So I think we need to look at this holistically. We can't do this in silos. We need to talk to each other because, as I said, disinformation and that part of politics being driven by usually private actors through the press is part of the problem as much as it will be part of the solution, I think.
Meg, I've noticed in recent years, I'm counsel to Alaa Abdel Fattah, who's currently arbitrarily detained in Egypt, and I noticed the special procedures, not working in silos, but speaking in one voice. Is this something that is sort of developing? Has this always been the case? Where do you see it at the international level?
So I think we have always worked together, but when there are very serious issues, I think, and particularly when there are crises internationally, we've found it really important to work together. And then similarly, as in the case of your client, I think it's very important that specific mandates work together, and the purpose is really to say this is clearly a violation of this range of rights if these facts are proven. That's my UN speak. I just want to mention, because we're talking about journalists,
yes,
that one of the other pieces of kind of my recent work has been on efforts by great economic actors to utilize and instrumentalize the judiciary. So both to influence who becomes a judge, but then also to utilize the legal system. And here, of course, slaps are a very, very important element of that instrumentalization. And so one of the things that I'm doing within my mandate is looking across other mandates to see how have different mandates dealt with this issue. Not only slaps, but also what's often been called judicial harassment, which I don't like, or legal harassment. And I think legal harassment is a term we might come to use. So I'm working on a position paper that will define this more clearly to say this is when the legal system is being inappropriately used to, as in the example of slaps, to shut down public participation, to go after journalists, to go after judges and lawyers. And so I'm hoping that we'll be able to kind of influence the other mandates that we would use this vocabulary in a way that becomes, I'm not trying to make everyone uniform, but that we can start to utilize this term such that the idea is more popularly recognized and we can identify it as a human rights violation more readily.
Well, slaps, interestingly, coming to inform the jurisprudence, certainly of the Inter-American Court. Just by way of, for those less familiar in the audience, this is the idea that an independent journalist may receive a letter from a very prominent firm of solicitors or law firm engaged for a high net worth individual, for example, saying that if the journalist pursues the story, that they will be sued in a personal capacity and risk, losing their home and so on and so forth. And this has had an enormous chilling effect, especially for journalists who don't have the protection of a big media company. We've got 10 minutes left. I think we've got time, therefore, for some questions from the audience. Perhaps I see microphones in the middle of the room. Please come up. Please just introduce yourself and ask your question. Madam.
Thank you. What an amazing panel. Thank you so much for putting it together. I'm Stephanie Ferris, a longtime law professor, former legal director of Amnesty International, and currently working as a volunteer lawyer with Trial Watch program of the Clooney Foundation for Justice. So we've heard so much about challenges, and I'm wondering, is it possible to identify some of the strategies to push against these challenges? I realize so often it might be just a case-by-case basis, but I'm wondering if there are some lessons learned from what has been useful that can be applied. Thanks.
May I do the unconventional thing and start by answering that question, and then
you're much better placed than me at the moment, at least, to answer that question.
Yes.
So,
only because my answer also includes the Clooney Foundation. Look, when my predecessor on the high-level panel of legal experts, media freedom, was Amal Clooney. I recall to this day we were thinking about what could be done for journalists who had to get out of their country very, very quickly. And we identified together, and as a panel, various pathways, but the problem with the pathways is they were either overburdened, it was too complex, it was too expensive, and it was certainly not fast. And part of Amal's genius, her challenge to the states when she was deputy chair was to adopt this emergency visa instrument that we established as a panel. And the states, to be fair to them, did do that. And she said, if you could just agree to or commit to 50 such emergency visas for journalists at risk, and why do we need to keep it focused on journalists? Let's make it human rights defenders, including journalists. Canada moved first, then Czechia, then Latvia, then Estonia. And this was all happening before the invasion of Ukraine. But it did mean that after Ukraine was invaded and independent journalists in Russia and Belarus were looking for safe refuge, really on an emergency basis, 8 members of the Media Freedom Coalition were able to grant 1,800 emergency visas for journalists at risk. And it's just an example of anticipating an issue. I'm not suggesting that we anticipated the illegal invasion of Ukraine, but anticipating an issue, setting a new legal instrument up, and then persuading the states to adopt it, and then seeing the states adopt it. So, some reason for hope, but Meg,
yeah.
What about you?
This is a great question, coming from Stephanie Ferrier, who I think told me to go to law school originally, back in the day. So I think solidarity is really, really important, and it's an easy word to say and maybe harder to actually activate. But I think in particular, what I've seen in multiple countries is when the bar really organizes itself, sometimes through the formal bar association or law society, and sometimes through informal networks. But when they really are able to speak for the rule of law in a way that people can relate to, right? I think that really starts to change the discussion often. And then I just will say here in the US, I've been really moved by the work recently done by a judge named Judge Esther Salas, who probably many of you have heard of, who's lost her son to an angry litigant who came to her house and shot him. And she has really called for the bar and for regular people, as well as judges, to join together and to make their voices known in support of the rule of law. And I believe that there are a bunch of events happening around the country on May 1st. And I'm not sure, but I think so. And I'm looking at one of my colleagues who maybe can correct me if I'm wrong. But I think that kind of solidarity action is really, really important.
Tim.
Can I perhaps just from the point of view of litigation and a court, I think this is where the answers need to lie, at the policy level, persuading states to provide a mechanism to protect solidarity amongst the bar or those in the service of justice, the bar and the judiciary, in order to protect each other and to make clear to everybody that is just, you provide protection to each other. The only way in which litigation can help, and one of the problems with litigation, I think we see that in many of the states affected, is it just takes time. It's a slow process, and I make no apologies for that. It needs to take its time, which means at best, in parallel with these efforts which provide immediate relief, it is then perhaps important and useful to identify the right kind of cases which can lead, after the process has been gone through, lead the court to kind of shore up that effort, explain that in fact that was always backed up by the law. But I think that's where court and the route through the courts is never likely to provide immediate relief. It's always going to be a slow process because, as I said, when you asked me about the criticism of my court, I think one of the answers is courts need to continue to act as courts and to provide a fair hearing to both sides, as much as observers might find that difficult at times, but it needs to be done, and that takes time.
Perhaps we have less than 4 minutes left, so perhaps we could take questions or comments in one go. If you could introduce yourself, ask your question, and then cede the floor.
Hello, thank you for this amazing panel. My name is Atakan Güngördü. I'm a senior associate at CBC Law from Istanbul, Turkey. And as a lawyer practicing in Turkey, unfortunately, I lived through all these examples of attacks on the independence of the judiciary and the rule of law. And I've represented clients who were targeted in these attacks. But my question is about the future. So after a power transition, how to repair the judiciary and how to go about repairing these institutions that were hollowed out for decades. Thank you.
And perhaps we could have the second question and comment, and we'll take them all at the same time.
Thank you. Thank you for this incredibly important and timely panel. My name is Rebecca Shute. I'm the co-convener of the Washington Working Group for the ICC, and I'd like to commend Professor Satterthwaite for all of your solidarity over these last months that we've been grappling with the threat and now the reality of the sanctions regime. So my question, I think, stems from your comments as well as those of Professor Yeginsu's. Where I sit, we've continued to engage in advocacy on the Hill, especially as the Senate still has the possibility to consider sanctions legislation. We are on the defensive with regards to the executive order. We commend the members of the Washington Working Group for the ICC, led by ACLU and now OSJI, who have led strategic litigation on behalf of plaintiffs now, as they did in 2020. But what can be done to galvanize the legal community, the public at large, and to your point, Professor Yeginsu, the journalistic community as well, to take notice? We had a press briefing with a Nobel laureate and 3 eminences from situation countries the morning of the Senate vote on the sanctions legislation that passed the House. And we only had a handful of media show up. And we understand why that is. This is a deliberately confusing time with an incredibly convoluted and busy media landscape to navigate. So how do we get this issue to the front of the table? Thank you.
We have less than a minute, but 2 phenomenally good questions. Meg, can we start with you, and we'll just...
Oh, gosh. These are really hard questions. So the how to recover from autocracy, I'm hoping there might be some answers from over here.
I'll try.
Okay, great. I mean, it's very important, and you have to follow the rule of law is one of the difficult pieces of that, right? You've got to rebuild a rule of law with the law and within the law, and it can be very, very challenging. In terms of the sanctions and the what can be done, so I guess 2 things. One thing I would just like to mention, the blocking statute. That doesn't answer your question, but I do think it's important that the EU activate the blocking statute to protect the court. So that would be one thing. But I think that we need more stories that really humanize the cases that are before the court. And for whatever reason, I'm not seeing those here in our kind of jurisdiction. And I think those would go a long way to showing why the court is so important and why it's so ridiculous to be sanctioning this court that's trying to impose accountability for the worst crimes.
Tim.
So I'll skip the question about this jurisdiction, as it's way out of my depth. But in terms of answering, I think Meg has made the point, which is, I think, the important one. That it is a really challenging thing to try and undo it while sticking to the rules about the independence and impartiality of judges and their protection. Because the repair has to come from the executive and the legislature, but the separation of powers means that the judiciary needs to be independent from them. I mean, we're currently going through that, of course, in relation to Poland, where my court and the Court of Justice of the European Union have repeatedly and seriously, heavily criticized the peace reforms, as they called them, of the judiciary. The new government is trying to undo that, and that's proving challenging. And you can see that in the efforts the Polish government is making. It's a good model to learn from, and all the work the Venice Commission is putting in to try and help them develop standards in which they can do that without breaking the rules, which we all need to adhere to by dismissing judges who are sitting and are then said to be illegitimate. The problem is, once you get into that rut, the independence, the sacrosanct nature of the independence is no longer sacrosanct in either direction, and then the rule of law is in trouble.
Short answer from me before we wrap up. The universities. The universities are a critical part of this. It's why I teach where I teach. It's why you teach where you teach. I was in Istanbul 2 weeks ago. The chants outside my room were hak, hukuk, and adalet. Rights, rule of law, and justice from the students. And I think that that's got to be an entry point for all of us as well. That's how we build capacity if there is, or we ensure that there is capacity if there is a transition. And again, to bring other voices into the conversation, not just lawyers talking to lawyers from the same jurisdiction, but international conversations and interdisciplinary conversations. And on that note, I'd like you to join me, please, in thanking both Judge Eicke and Professor Satterthwaite today.
Thank you very much.